So today we are diving into a very crucial topic, and that's estate planning and why is it important to get our affairs in order. We've all heard of stories of families caught off guard by an unexpected tragedy and where the loved ones not only grapple with the loss, but they also face significant challenges with their financial affairs. Without proper planning, properties, businesses, bank accounts can become source of confusion and stress. Many of us, unfortunately, procrastinate in these matters, assuming we have plenty of time to sort things out. However, we all know life is very unpredictable. Having witnessed this several times firsthand, I felt compelled to create this video, and my goal for you is to shed light on why estate planning is so vital of protecting your family's future and to demystify the process. Because of that, I have today the privilege of having as my guest Brittany Britton from the Best Coast State Law. Brittany is a licensed estate planning attorney here in California, offering a range of services like creating trust, power of attorneys, medical directive, probate, trust administration, etc. One of the standout qualities of Brittany and her practice is her genuine compassion for her clients. She came highly recommended, and I have no doubt you will be very impressed with what she has to share with you. And with no further ado, I want to welcome you to our show.
Thank you so much.
And it's just so nice to have you here.
Yes.
So let's start with our first question.
Okay.
What is the difference between a trust and a will?
Yes. Okay, that's a great place to start. In all 50 states, in fact, the difference between a will and a trust is the same. If you pass away with only a will, your assets, everything from your checking account to your real estate, will go through the probate court before your beneficiaries can inherit from you. But if you create a trust during your life and you transfer title of your real estate into that trust, you can avoid court intervention in your estate altogether and elect to have your estate privately administered by someone you trust. That way your family never needs to involve the court system in the administration of your assets.
And we all know probate is no fun, right?
Yes.
Going through the court system. How long does it take usually?
Oh my gosh, my easy cases in LA County right now are 12 to 18 months long. Orange County, just our neighbor to the south, 18 to 24 months. And it's the cost.
It's horrible.
It's the cost of probate that really hurts these families. The attorneys and the administrators are paid a percentage of the estate.
Correct.
And that is the fair market value, not the equity. So if you have a home worth $1 million with a $500,000 mortgage, your attorney's going to get paid off that top line, $1 million. And families can get turned upside down really easily.
It's awful, awful. My next question to you will be, what is the best time to think and to create the trust?
Yes, now. My youngest trust planning client was 22 years old.
Good.
She had worked very hard to purchase a condo right down the street, in fact. And my oldest client was a gentleman who was 96 years old and had never had a will or trust. And we work with everyone in between. I say the answer is, as soon as you have an asset that you want to protect, it may be real estate, it may be a 401k you've been adding to, or maybe it's a life insurance policy that you purchased.
Okay.
Okay, but when you get that asset that you've worked for, let's protect it with a trust.
Yeah, I agree, because I think a lot of people think if there is no real estate, there's no need for trust.
Correct.
But yet there are people who have, like you said, 401ks, retirement accounts, or even cash in banks, savings account that needs to be taken care of.
Yes, perhaps you purchased a life insurance policy, but your child is 4 years old. We don't want to name that 4-year-old as the beneficiary of a life insurance policy. Instead, we want to name your trust as the beneficiary of that life insurance policy. Then within the trust, you get to decide how and when your 4-year-old has access to those funds.
Okay. So with that in mind, I know there's a difference between a living trust and a revocable trust. So explain a little bit.
Sure. So the most standard trust that you're going to see is called a living revocable trust.
Okay.
Living just means we created it while you were alive. Simple as that. The real difference is between revocable versus irrevocable. Revocable means you can change it. You can change your mind, update the terms whenever you want. Irrevocable means you can never change your mind. Most of my clients want that flexibility of a revocable trust so that as their family grows, as their assets change, they can come back to me and amend the terms of who inherits and when.
How often does somebody have to revisit the terms of the trust and update it or revise it?
Yes. My rule of thumb is pull these out every 3 to 5 years and make sure that they still represent your intent. With that being said, you know, clients have brought me trusts that they drafted before I was born. I've looked at almost 50-year-old trusts before, and they're still technically valid, but they're so far out of date. You know, the family now has grandchildren or different homes and things like that. So don't wait. I say 3 to 5 years. Some of those documents really are subject to tax laws as well. So you want to make sure that you're staying up to date on any changes in estate taxation.
So that was a good comment that you made. What is the role of a good CPA?
Yes.
And do you as a trust attorney work with a CPA who is handling the financials of that person?
Absolutely. Yes, the client who is going to be the most satisfied and the most educated at the end of the day is the client who has an estate attorney, a CPA, and usually a financial advisor all on their team. And in the perfect scenario, those 3 professionals are working together. You should not be getting tax advice from your estate attorney, and you should not be getting legal advice from your financial advisor.
Correct.
Right? We should be letting the professionals do their job, and I love working with CPAs and financial advisors because we're all bringing a different perspective to the client and allowing them to make a decision that works the best for their family.
Which takes me to another point. Can every attorney handle estate planning? Can every CPA handle this kind of thing? So what is the importance of being specialized? Because I know in real estate, specialization is very important.
Yes.
Can you touch on that?
I think you'll see a lot of large firms will sort of add on estate planning as a service that they can provide to their clients. And most of the time you're going to be getting a very generic boilerplate estate plan if you go that route, and you'll probably pay more as well. My firm focuses solely on estate planning and estate administration. So we are very specialized in what we do. I do it day in and day out. Can they turn around a legally valid document? Absolutely. But we really hold our clients' hands and are focused only on this matter. And I think that's the best way to go.
Okay, perfect. Now, who should you appoint as the trustee of your trust, and why is that important?
Sure,
part?
the $1 million question. This is, I think, the biggest decision that our clients have to make. The trustee is more commonly referred to as the executor of your estate. I think that's the more common term that people are used to. But the trustee of your trust is the person who is ultimately in charge of making sure your bills are paid, your final taxes are filed, and then protecting your assets and distributing them to your beneficiaries. Okay, so what I tell my clients is, it's easy for me to sell you on a trust. because we avoid probate. We've saved so much money, we're not in court. But there is a flip side to that coin, which is that we don't have a judge signing off on every dollar that's being spent. We don't have eyes on every transaction. A trust administration is private, which has many benefits. But if you choose the wrong person as your trustee, bad decisions could be made. Anything from neglecting real estate, neglecting to pay property taxes or homeowners insurance, to fraud, and where they're actually stealing from the beneficiaries. So who is your trustee? Someone you trust implicitly, someone who generally pays their bills and files their taxes on time. And if you have several kids, your trustee really needs to be objective and fair. They cannot choose favorites. We need someone that's going to step back and treat everyone equally.
That's so important. So important. Because we all know when money comes into play, we've seen judgments changed, right? So
yes.
I totally agree with you.
And hurt feelings and grief. There's a lot of emotion at this time. And so a trustee who's going to be able to keep their head on straight and make objective and fair decisions is going to be the best outcome for your family.
Okay. One other question that I have is the importance of recording these documents. Because I firsthand have seen how clients come in and it's not the real estate agent, it's the title company who is requesting the validity of the documents. So touch on the importance of recording every document through a title company.
Okay, so I can't tell you how many clients I've seen that come to me with a trust. Maybe they tried to do it themselves, maybe they went to LegalZoom, and they feel so confident with this trust, but they have not recorded the deed, updating the title of their real estate. That is absolutely necessary. Step one is you create your trust. Step two is you transfer your assets into that trust. And when it comes to real estate, as you said, that means you're recording a quitclaim deed where you transfer ownership out of your name as an individual and into your name as trustee of a trust. A title company or an attorney, some real estate professional must be doing this for you. Yeah. I can't tell you how many mistakes we've seen where individuals attempt to record these deeds on their own, and they will not be effective after you've passed away. Will be forced to go to court to fix that. So the recording is absolutely necessary. And a lot of questions that we get are, well, when I update title, won't I lose my Prop 13 property taxes? The answer is no. You will get to keep your property tax rate. People say, well, won't my mortgage holder call my loan? No, they will not. When you transfer your property into a trust, your mortgage stays the same, your property taxes remain the same.
What are some of the things which go into a trust? We touched on it before, but can you be a little bit more specific?
Absolutely anything that is based in the United States. So your checking account, your savings, your brokerage, life insurance, and of course real estate. Also business ownerships, private equity investments, intellectual property. I represent a lot of individuals in the entertainment industry, so they may have royalties, residuals, copyrights. All of that can be transferred into the ownership of your trust, which ensures that your loved ones inherit after death just seamlessly. Retirement are the only assets that we get a little more strategic with to make sure that we're maximizing the tax advantages of a retirement account. They can go into a trust, but we should do so strategically.
Okay. And one last question before we end part one of our interview is, can you tell us the difference between a will and a trust? Did I?
That was where we started.
That's where we started.
And that's where we should end, though, too, because this is what everyone always forgets. So a will means your family's going to be in probate court, And a trust means your family is going to privately administer your estate. It's really as simple as that. Will, public record, trust, private administration.
So the reason why I ask that is if I write my will on a piece of paper and think that, okay, this is it, and take it to notarize it and give it to my kids and say, okay, here's my will. Does it go through the same probate process?
It absolutely does, although the will you just described would not be valid in California because wills are witnessed in California, not notarized. But conceivably, if you wrote your own valid will, had it witnessed, it would be accepted and the terms would be followed, but only after your children opened a probate. And they'd be spending, again, 12 to 18 months in LA County Probate Court, and they'd be paying their attorney tens of thousands of dollars.
Okay, so the wisdom in this is, do not try to be too wise or not want to spend the money with the attorney, with the trust, creating trust, because ultimately the cost will be so much higher, except this time it will be your family who is going to be paying for that.
Absolutely right. Mm-hmm.
Great. Thank you. This was great.
You're welcome.
This will be the first part. If you have any questions that you want to be answered, please go ahead and write down your questions. We will get back to you. And of course, Brittany's contact information is on the video. Feel free to get in touch with her and let her take care of you. The only request I have is, please, when you call her, tell her that you've seen the interview so that at least she will know where you're, referred to her. Yes. Last but not least, if you like this video and you would like to see more interviews like this, please click the like button below and subscribe. Thank you, and see you in the next part.